हेलो फ्रेंड्स, वेलकम टू शॉर्ट हैंड विद विनय। ये डिक्टेशन 110 वर्ड पर मिनट होगी और इसका पीडीएफ डिस्क्रिप्शन बॉक्स में दे दिया गया है। साथ ही इसमें जो टफ आउटलाइन है उसकी भी पीडीएफ डिस्क्रिप्शन बॉक्स में दी गई है। तो चलिए स्टार्ट करते हैं। 3, 2, 1 स्टार्ट। This appeal arises out of an unfortunate dispute between the appellant number 1 dash wife and the respondent number 1 dash husband over the custody of their minor male child Aditya Kiran. Full stop. This appeal takes an exception to the judgment and order dated 31st August 2021 passed by the learned single judge of the Punjab and Haryana High Court in a petition for habeas corpus filed by the respondent number 1 herein for seeking custody of the minor. Full stop para. The respondent number 1 and the appellant number 1 married in New York, United States of America, bracket start, for a short within double inverted comma USA bracket close on 30th January, 2011. Full stop. The child was born in USA on 21st January, 2016. Full stop. Thus, the child is a citizen of USA by birth and is holding a USA passport. Full stop. Unfortunately, the child was diagnosed with hydronephrosis, which required surgery. Full stop. It is the case of the respondent number 1 that as they were not in a position to secure an appointment of a doctor in USA for surgery, it was agreed between the appellant number 1 and the respondent number 1 that the child will undergo surgery at Max Hospital, Saket, full stop. As the child is a citizen of USA, consent for international travel with one legal guardian was executed by and between the appellant number 1 and the respondent number 1 on 4th February 2019, full stop. The consent was recorded in the said document to enable the child to travel with the mother dash the appellant number 1 to India, full stop. The consent was executed for the period between 5th February 2019 to 26th September 2019, full stop. The consent document recorded that the child will be leaving USA on 5th February 2019 and will be returning back to USA 26th September 2019, full stop. It was further recorded that any change to this plan shall be discussed and consented to by both the parents, full stop. A certificate dated 17th September 2019 issued by Dr. Anurag Krishna, Director, Pediatrics and Pediatric Surgery of Max Hospital, Saket, New Delhi, records that the child underwent a surgery on 14th March 2019, full stop. It records that he had examined the child on 12th July 2019 when he found that the child was doing well, full stop. Dr. Anurag Krishna has recorded that the child needs to be reviewed to 6 to 7 months post-surgery along with a fresh ultrasound and renal scan, full stop para. It is the case of the respondent number 1 that at the time of surgery, he flew down to India, full stop. After the surgery, he returned to USA for his work, full stop. It is brought on record that the respondent number 1 has a status of permanent resident in USA which is valid up to 16th August 2031, full stop. According to the case of respondent number 1, the appellant number 1 violated the international travel consent by not allowing the minor child to come back to USA by 26 September 2019, full stop. According to the respondent number 1, the appellant number 1 detained the minor in her illegal custody in India, full stop. Therefore, the respondent number 1 filed a petition on 30th January, 2020 before Circuit Court of Benton, USA, which according to the respondent number 1 is the court of competent jurisdiction. Full stop. The petition was filed for seeking primary care, control, and custody of the minor on account of his wrongful detention outside USA. Full stop. On 3rd February 2020, the Circuit Court passed an interim order granting primary care, custody and control of the minor child to the respondent number 1 and directed the appellant number 1 to return the child to the respondent number 1. Full stop. In the petition for habeas corpus filed by the respondent number 1 in the High Court, he has stated that though a copy of the said order of the Circuit Court, was forwarded to the appellant number 1 by email, she continues to detain the minor child in India. Full stop. In these circumstances, the respondent number 1 filed a petition seeking a writ of habeas corpus in the High Court of Punjab and Haryana and prayed for a direction to the state of Haryana to secure the release of the minor child from the illegal custody of the present appellant. Full stop. The appellant numbers 2 and 3 are the parents of the appellant number 1 who are residents of Gurgaon in Haryana. Full stop. At present, the appellant number 1 is staying with them. Full stop. Various interim orders were passed in the said petition from time to time. Full stop. The High Court appointed a learned counsel as amicus curiae, who interacted with the appellant number 1 as well as the respondent number 1 on phone/WhatsApp calls with a view to ascertain their respective stands. Full stop. He also submitted a report. Full stop. By the impugned judgment and order, the writ petition filed by the respondent number 1 was allowed. Full stop.